Does my child have a say on where she will live after divorce? Hi, I'm Bill Farias, founder of Farias Family Law, and this is a question commonly asked by people who are approaching divorce who have a child that has a strong preference about where he or she wants to live. The answer to this question about whether the child's voice matters is that it depends. I know damn lawyers can never give a straight answer. It always depends. Well, the reason for that is that this issue, like many other legal issues, is nuanced and fact-specific, and there isn't a black and white answer. But what I can do is help you figure out how to think about this, provide a framework for how to approach this. So first, the overlying principle when assessing child custody and parenting time is that the court aims to do what's in the best interest of the child. Now, what does that mean and how is it defined? It depends on a number of factors. Who is the child most bonded to? Who is the primary caretaker? Is there a particular community that the child is more rooted in? What are the parties' work schedules? Does the child have any special needs that either party is better equipped to handle? And a number of other factors. On the issue of when the child's voice matters, generally the older the child, the more likely it is that the child's voice will weigh more heavily in helping the court decide what to do. So, for example, once a child is about 14 years old, roughly, depending on the child's maturity, but once a child is about 14, if the child has a specific preference on a living arrangement, then in most cases, unless there is a serious issue with the parent the child wants to live with, the court will allow that. And the thinking behind that is that for the most part, it can be futile to prohibit a child from a specific living arrangement. So if you're not going to allow the child to live with a specific parent, then maybe the child starts to run away, maybe the child starts to act out and engage in behaviors that are overall destructive. So the older the child, the more weight is given to the child's preference. The younger the child, the less weight. So the child's voice can still be heard if the child is young. For example, in some cases involving custody and parenting time, the court may appoint a guardian ad litem. That's an individual, usually an attorney experienced in family law, who investigates the facts and circumstances of a case and makes recommendations to the judge on the issues of custody and parenting time. And the guardian ad litem usually interviews the child as part of this process. So the report that the judge will read and take into consideration will include statements from the child, or it may include statements from the child if the child is interviewed, but that's usually what happens in a GAL investigation. However, the younger the child, the less weight the court is going to give to those statements, and the more closely the court is going to look at all of the other factors. So whether your child's voice matters depends on the child's age. The older the child, the more weight will be accorded to that child's preference. And the younger the child, the more likely it is that the court is going to closely examine all of the other factors that they take into consideration in determining custody. So if you have any questions on this, you can feel free to call us at 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this helpful, feel free to share it with anyone you think might benefit from it, and you can subscribe to our channel. And you can also find us on Facebook at Farias Family Law. Thank you. Have a good day.